Welcome. We're going to go ahead and wait for some people to join the broadcast. And while we do that, we'll get the preliminaries on out the way. Welcome. This broadcast is about law and court practices. Um, this particular video is overview. This video that we'll be watching on display utilizing the Screenshare feature in the broadcast. We just uh, did some research on court practice, and one of the video suggestions in the query um, was uh, suggesting that we take a look at this uh, presentation. This particular uh, gentleman will tell you what he what type of information that he provides on his channel, but this particular broadcast is purposed to give you some variety of information concerning court practice, just for a general understanding of law and equity. Because it's very important to understand where these procedures come from, how they got started, to have some understanding of the importance of each aspect of it. And so I think he does. I watched a little bit of the video, and I think he does an excellent job of summarizing the events that took place, um, to get us up to speed as to how our court systems work, and the background, um, which lays the groundwork for uh, the systems that we have in place currently, and also give you some idea of the level of court authority that is placed upon each jurisdiction or judicial authority that's given to each district or each faction. All right. Now, um, he doesn't make it real clear uh, which courts is which, but the most important thing is that we understand that there is a difference between going to court for what he identifies as a common infraction, or uh, I lent somebody $50 and they didn't pay it back. It's totally different um, procedural uh, guidelines that is either allowable or is, the common practice, because of the severity of uh, the importance of equity. Yes, somebody commented equity is super important, extremely important, because equity derives from interest. When you have interest in a procuring cause, that in itself places some attention on the matter, simply because it can affect others. In other words, if you don't make money and you intend to employ people with the money that you potentially were going to make, and someone stops you from making that money, then inevitably that is a ripple effect that's occurring, because now you have you not making money, okay, and the potential of the uh, uh, ability of having the finances to fund employees and pay other people money, okay, to provide services for you, or pay your vendors, okay, that's a whole nother aspect. The vendors won't get the money if someone stops you from making the money initially. This is the the procuring cause of a claim, because it affects more than one thing when that type of action occurs. It stops the people from who could potentially already be employed by you. It could cause you to not have the finances to continue paying them, which means that uh, they also experience loss. Okay, and the damages to their social structure that it uh, is consequential. Um, we could go on and on and on about the implications of loss and damage that could occur from someone causing you to lose money. This is very realistic, and it's not fabricated in the fact that uh, when proven up, uh, that okay, you had a business plan in place, and so forth and so on, and that this would have uh, occurred if not been for the collateral damage that was caused by someone else's adverse action. It could be somebody defaming the organization, or something of that nature that could cause and affect the outcome of the circumstances surrounding your organization. Okay. Sometimes that's harder to prove than other times. Other situations that are direct impact can be proven direct impact, then you've got you a good case. We're going to go ahead and get started. I think I've done enough to prep you for the information that's being displayed. I say prep you, that's just to make you aware of what we're displaying, but this is an adult channel and an adult broadcast. So as an adult and a mature adult at that, you are responsible for your own thoughts. And because thoughts are things, you create the things in your mind, all right, that you uh, deem as valid or whatever. So everyone is essentially responsible for themselves. Let's get it.
Did you know that there's a 1,000-year-old court still operating in the United States and none of us really ever talk about it? I'm Brian. I make videos about law and civics, and they're not as popular as some of the others. So please comment, share, repost, do what you got to do to get this video out there so people can see it. Because this is the story of the Court of Equity. And it's part of your law, so you should understand it. Right here in the U.S. Constitution is Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, etc. What is equity and why is it different from law? Let's find out. These are the federal rules of civil procedure. And the second rule in here says there's one form of action, the civil action, which makes sense because these are the rules of civil procedure. You're filing in civil court. Of course, you're filing in civil action. But when this rule was written in 1938, it made a huge splash because in 1938, when these rules were passed, there were two civil actions, law and equity. And Rule 2 basically wiped the court of equity out of existence. But while most of the equity courts are gone, equity law is still alive and well, and I will tell you where it's hiding. Real quick, very tempting to see this as some sort of conspiracy theory. It's not. The reality is way more boring. When I was in law school and we were learning this stuff, nobody paid attention to this. Nobody was that interested in equity. My guess is most people learned it for their exams and then forgot about it completely. It's one of those things where sometimes you have to write some different words. Wait, there's special rules that apply here, right? What's that called? But nobody pays attention to it. The only reason I did is that half the reason I was interested in law was the history. Plenty of stuff was boring to me too. So for a lot of lawyers, equity is just one of those things you don't pay attention to. You could probably go through an equity case and not even know it. But I still think it's something you should learn about, so I am going to teach you. As usual, we're going to start with some history. Historically, courts generally looked at 4 different kinds of law: government stuff, land stuff, commerce stuff, and crime. And I've explained in some other videos that commerce and land tend to be handled differently because commerce disputes can usually just be managed with money, while land we look at as something special that you can't just replace with another piece of land or some extra money. So let's take a look at how these courts were set up. So way back when we have our court.
I want to do a little bit of explanation on what he just said about the difference between how a case is handled as it relates to land, and how a case is handled that relates to any other thing, okay? Because as he stated, land is something, it's not something that you can replace with money. It has what's called a unique factor, all right, that cannot be well, in court, anytime a claim is made, the whole purpose a claim is heard or called to order is because there's a claim that something is missing, something went wrong, okay, whatever, something going on, an event occurred that caused the problem, okay, somebody did something, all right, somebody said something, somebody acted in a way that caused harm to another person or persons, okay. Now, in that regard, when it's involving land and you cause a problem involving land, that is considered a more serious and unique event because of the fact that that's something you can't replace. If I took your cow or your horse or your man, all of those things can be replaced with something of the kind. In other words, even if I took your man and you may think he's unique in some type of nature, the fact that he could be took shows that he's not unique in any way. But we're gonna stay on more realistic topics concerning money or loss or true damages, okay, that can be claimed in court. And why is land so important? Why is land handled in a totally different manner. And I've spoken on this before. First and foremost, a lot of people are not even viewing land as they should in regards to the understanding that land. Okay, let's go back to the Little House on the Prairie days, all right? And those who are familiar with Little House on the Prairie, there was a family that lived there. They had built a house, and people helped them in the community and so forth. I think they create built a farm, all right, and they lived on the land. They lived off of the land, okay, because land is that one thing that if you have land, you can pretty much survive off of having that one thing. If you have, uh, so the land essentially affects everything, okay? Having the land, it affects everything in your whole life, okay? If you live there, uh, that's your dwelling place, okay? You can just live off of the land. You don't have to erect a structure or anything. Some people like the outside and the wildlife and may build some type of housing structure or that is not the traditional, in a traditional manner. They may use, like I've seen some build underground caves on their property and live in there, um, so that they don't alter uh, the nature of the land, okay? And they respect nature, so they don't want to alter the land by building anything on the land, okay? And you also have people who literally use the trees and materials from the land that they buy. They they timber the wood, timber the trees on the land for wood. They use the actual trees that they cut down from off of their own land to build a housing structure, okay? No different than what any other animal species would do. Ants use whatever dirt, shit, around to uh, build their little ant bed, and they build an ant bed using the soil in whatever area they want to take over. And so, uh, in that regard, uh, that is a natural occurrence uh, that is considered to be uh, more valuable in nature than anything that's erected from fabricated uh, materials. Um, it the house itself becomes a part of the land. Okay, and so we have veered away from that, but the value of that has not diminished and has not been reduced in terms of law, natural law, things that are important, things that have value, that cannot be replaced, cannot be reduced in value, and cannot, uh, 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 you can't destroy, energy can't be destroyed. It can be moved, it can be uh, shape shifted, but it cannot be destroyed. All right. Fact that has, it's an undeniable fact and unrebuttable. Okay. It has precedence to prove that it's unrebuttable. Okay. It's a fact, Jack. You understand? So when you have a rule of law that strong that has survived throughout uh, humanity, the existence of humanity is a fact that stands and cannot be rebutted. Okay. Um, Now, can you defy the law of gravity? Oh, we have proven that the law of gravity exists but can be uh, shape shifted. Okay, you can another law, the laws of force, um, proves that with the right amount of motion and or energy placed behind something, you can uh, reverse the action of gravity. The law of gravity, you can reverse it and utilize it in another manner. Okay. Um, well, they probably don't view it as that, but that's exactly what they're doing. They have not erase gravity because a plane will fall out of the air just as hard as you can powerfully thrust that motherfucker up there. It can also uh, lose momentum and drop the fuck out the air. Okay, that part. So, indeed, the laws of gravity still existed, even though you apply another law that would affect that specific plane. Okay, it thrust it on into the air. But the laws of gravity were still current and in full effect when them propellers go out. Alright? In full effect. um, if you do not have an active uh, force that is opposing that law in that space, then the default is gravity. Okay, that's my point. All right, the default is gravity. And that's based upon density and all these other factors, whatever, that keep you grounded. All right. Same thing in law. We can add all kinds of other stuff to, you know, govern ourselves by. But the true laws that have proven themselves to be fact remains the same regardless. Regardless. And so that's the same as with gravity, and also equivalent in nature is the law of equity. Uh, the one main rule that I'm aware of that the Christians were, you know, preaching and teaching in when I was going to church is that uh, you do unto others as you would them to you. All right, and they call that the golden rule. And they call it the golden rule, I'm assuming because it's a rule that governs everything. 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 If you want somebody to treat you right, treat them right. If you want somebody to respect you, respect them. If you want somebody to pay you, be willing to pay somebody. That part. Okay? And so that is pretty much how equity works. If you created an obligation by causing a financial hardship on someone else, that's what we call uh, punitive damages. All right. So when you cause somebody else some type of financial harm, then why on earth would you think it would be okay for you not to pay up or do something to correct your actions? And since you have people that were raised that they can do whatever the fuck they want to do and don't have no consequences because their parents didn't beat the shit out of them when they should have, you have these type of people that do things and don't expect consequences. Some people don't even understand the concept of consequence. That's uh, why we have courts, because if there are people who don't understand, not even in the least little bit. You can hear them sometimes when they're speaking. Uh, I watch court cases. Sometimes we present court cases and we discuss them on this channel. Um, and we discuss what's going on. All right, in real cases. Okay, real cases and claims. Years ago, they used to have a show called People's Court. People's Court. And you would notice that people who watch it, they watch it with family members and so forth, and they discuss it on a sideline, and so uh, the MC or the person that was uh, describing what's going on in this case, he would make little funny titles about the case. And this is the case of the slumlord, uh, and this and that, and this and that, okay? And he would make, you know, the title of it interesting to draw you in to make your decision. He would ask you a question. Who do you think is right in this case? And he would ask you that right before the judge um, makes a decision. He would also ask you afterwards, did you think that the judge's decision was fair and accurate? Okay. And in that regard, people must understand that laws are created by the opinions of we the people. We the people. Because they affect who and what? We the people. Okay? And what's going on in our lives, all right? In our social structure. This is why Social Security is so important, because they are, are have drafted their trust with uh, the constituents uh, that they they're part of the contract is to perform uh, investing and so forth for the shareholders of the trust, all right, and the beneficiaries of the trust. And so, in that regard, that's their fiduciary responsibility for the social structure of the United States. Okay, of these United States, and you, if you follow along on our broadcast as we talk about states and estates, those words are interchangeable, especially when you're talking about land. Having your own land is a very powerful uh, financial uh, strategy. All right. And when I say financial strategy, is you really not even considered as nothing as a having a bona fide stake in the game, and that's the game of life, economics, whatever you want to call it. You don't have a stake in the game unless you have property. And some people say, well, my family got, but they don't have nothing on the record that states what they particularly have, what interests they have, and any type of movement or action with that interest. It's just sitting still. When it's just sitting still, it's just like a target. It's not a asset. It's not a value to you if it's not moving. It needs to be moving. And what I mean by moving is something need to be placed on the record as to what's going on with this in current times. Because even if a business is in business for a long time, or a family has been thriving in an industry for a long time, that shit can fall off from generation to generation. Perhaps if your family had a farm on the property, and it's family property for years and years and years, and uh, they didn't procreate enough to substantiate the existence of that family property being kept up and maintained in the capacity that they had originally operating on. I'll give you a good example. Perhaps the great great grandfather obtained the land, got deeds on the land, and willed it to the family in all blood relation. And then so forth throughout, okay, the great grandfather and the grandfather and so forth, they continued on that legacy. But perhaps the grandfather didn't have sons. And a lot of times that's when the link is lost, when there's no heirship, male heirship. Male heirship carries the name. That's the reason why there's no continuation of male heirship. Okay, and this is the reason why there was a beginning of women uh, despising their wombs, so to speak, when they didn't have male, uh, when they didn't have male offspring, because the males were the ones to carry the wealth and finances of the family. Now, we do have queens and so forth in royal families that can carry on the wealth. Uh, and so there was a loss of wanting to even a desire to want to have a family structure that uh, emulated the structure of monarchy. Okay, so that's why you have this other family structure that surrounds the male gender here here and in other places of the world. Now, I don't have a problem with that. The the only thing that uh, denies that as being uh, a foundational structure is that the fact that a woman could have a situation where she doesn't have any male offspring. And so, does that stop the man from willing the property and land and so forth to his female offspring? No, it does not. No, it does not. So, in that regard, um, that's a little crazy to even think in that manner as if you could not pass on that legacy um, and just to allow the family to die out because there was no male uh, figures involved. Now, in reading the Bible, I did notice that when it was uh, like Laman, I think Laman or whatever his name was, Laden, in the Bible, he had uh, two daughters. He didn't have a son. I don't think they didn't mention because the stories was all about his daughters, and that he had a need to marry off uh, the daughter that he felt wasn't as uh, desirable because she had I think she was cockeyed or something like that. Something fucked up about her. She had a lazy eye or something like that. The point is, she had a physical feature he thought men wouldn't desire her because of it. Okay, and that it would be hard for him to marry her off. So it may have been their customs that she would need a male in order to pass on inheritance or family legacy or whatever. So when I forgot his name, Isaac, whoever it was that was coming to try to get him a wife, he liked the pretty one, of course. And so he was after the pretty one, and he made a deal with the father to get the pretty one, that he'd get his money up and work for him and get his money up and show him, prove himself, so that he could give his hand in marriage to the pretty one. But the father tricked him and told him, man, I can't give you uh, this daughter because it's going to be harder for me to get the other daughter a husband. And so they worked out a deal where he couldn't make him give him his hand in marriage. So whatever kind of deal they had on the handshake, he couldn't do nothing about it. All right. So he still uh, carried on and patronized conversation enough to work a deal with him to take both the, the daughters, marry both of the daughters, and apparently that was okay in their customs for them to do. So he worked for him for both of the daughters. Then he tricked them again. But anyway, that was the whole point I'm saying about that is this. Is that the woman needed the father uh, tricked him and told him he don't have enough money or finance to be able to take care of both of his daughters. So he tricked him into working for him a little bit longer to make some money and have his own shit. And so he worked a deal for that. But the point is that the women in that type of custom were given over in marriage. That's what they call it, given over in marriage, arranged marriage type of situation, to ensure that they have a male figure to cover them and protect them from any like people would just come in and fight the woman and take her property, take her, rape her, whatever, rape, pillage, all of that, and this is why you have these heroic stories of women who didn't tolerate that, and they were known for busting a cap in the motherfucker ass to protect their shit, okay? And because inevitably, a woman is a human being, and what they call that fight or flight gonna kick in. People say you back somebody in the corner, they gonna come out scratch you. All right, all of that go. Um, we're gonna get back into the broadcast because I may have gone off on the deep end a little bit. We're gonna really back in. Let's get it.
Courts handling property, we have our courts handling revenue, taxes, government stuff. We have our courts handling crime and civil disagreements. The only thing the king really cares about is his money and property. Because the king has his finger in all the property, and obviously tax revenue is going to be his deal. King couldn't care less about local crime and petty commercial squabbles. Those are handled by small local courts and regional courts, and by manor courts. So if you're a peasant and you get screwed in a contract, you go to the lord of the manor. Think Downton Abbey. Then along comes King Henry II, late 1100s, and he decides to reorganize all the courts.
Hi, I'm Amy Poehler, and I'm standing in front of a bunch of books, which means I'm smart and you have something to learn from me.
Henry II, late 1100s, and he decides to reorganize all the courts. So Henry creates the Court of the Exchequer, the Court of the King's Bench, and the Court of Common Pleas. Court of the Exchequer is going to keep handling all the stuff he cares about. The Court of the King's Bench is going to be like a regular court, and it's going to handle all of the crime and any civil infractions that are kind of crimey, what we call civil breaches of the peace. And the Court of Common Pleas is going to handle all of these civil questions, so any kind of commercial stuff. Got all that? Now I'm going to make 700 years magically disappear. The Court of the Exchequer is going to change its name to the Court of Chancery. It's not what really happens, but we don't have time. It's named after the Chancellor. Today, we don't really care about criminal law. But for like the next 700 years, these three areas of court are going to fight over who gets to control what. But in the end, it's still going to end up looking pretty much like this. All right, we don't really care about revenue anymore. But slowly, we're going to get Court of Chancery, Court of the King's Bench handling crime, Court of Common Pleas handling civil. Now, I'm going to put some more familiar names on a couple of these. The Court of Common Pleas is also known as the Court of Common Law. The Court of Chancery, also known as the Court of Equity. So let's talk for a minute about the differences between these two. The Court of Common Law follows, like I said, a more structured regimen, and one of its primary defining features is what we call stare decisis, which means we stand beside the decision, or I stand beside the decision, he, she, it stand beside the decision. That means that common law courts are locked in to prior decisions made by other common law courts or by itself, and the common law court has to follow it going forward. The common law court is also usually stuck resolving things with money. So if somebody breaks a contract with you and you lose $10 in the deal, the common law court can get you your $10 back. What about equity court? The Chancery Court, Court of Exchequer, whatever it is now, has a totally different set of rules. It operates under equity. While common law is stuck with its old decisions and common law is stuck solving problems with money, equity is less stuck to those old decisions, has a lot more freedom to make new decisions, and it has the ability to force what we call specific performance. That means it can force somebody to actually do something or stop doing something. And the reason I've been talking about property is that the equity court comes along to do things like say, hey, you have to sell your property to this guy because you agreed to do it, and we see that property is different from other things and can't be replaced with just money. Equity court is important because it fulfills a need that common law can't fill. Also, very importantly, the chancellor, who again, Chancery Court is named after, had the ability to put you in jail if you didn't follow his decrees. So we call this the equity doctrine. The courts are more flexible, they're more fair, they have a little bit more opportunity to kind of do what they want, as opposed to the common law courts that are locked in with these old decisions and with money solutions to fix problems. Equity courts are more equitable, fair, equity. Okay, so now let's talk about equity in America. That's all England. A lot of the states set up common law courts and equity courts as separate buildings. Not every state had separate courts, not every state liked equity, but a lot of states did. But unlike some of the states that had like separate buildings for common law and equity courts, the federal court system always only had one court building. Actually, let me draw this out. So up at the top, you see the judges and the buildings. In the states, sometimes were different. At the national level, they were the same person. The language of law and equity could be completely different. At least early on, actions in equity were really long and complicated. The rules of law were based on common law. The rules of equity were kind of touchy-feely. They could switch around a bit. The remedies at law were mostly money, while the remedies in equity were very different. You had a lot of flexibility to make changes. And generally, their philosophies were very different. And it was recognized from a really early time period that common law had shortcomings, and that's why equity was important. But equity also had shortcomings, so you couldn't just bring anything in equity. But then 1938 comes along, and this guy's written. And people were already getting fed up with this complicated system. So the states were also leaning towards wiping this whole mess out. So let me show you what the Federal Rules of Civil Procedure did in practice. Obviously, at the federal level, we didn't have two sets of judges and two sets of buildings. But as the federal rules took hold, a lot of these separate systems either were already wiped out or were wiped out entirely. The only one to still exist is in Delaware, which still has a Chancery Court named after the Chancellor. So now we just have a court, which at federal level we had anyway. But we also only have one action. So a lot of the language is simplified too. Some of it's still different, but a lot of it's the same. Similarly, a lot of the rules get mixed together because now we have this, and this sets the rules for both. So while the law they're following is common law and equity, a lot of the rules are now the Federal Rules of Procedure. But the real problem is that the remedies stay different, and so do the philosophies. And they still exist to this day. What does this all mean? Well, today you may not even notice that there's a difference if you file a common law case versus an equity case. The differences aren't that extreme, but if you do know the difference, it might help you out a little. So let me tell you some of the biggest differences between the two. First, obviously the constitutional difference. So the writers of the Constitution knew that equity existed all the way through. But the Seventh Amendment, which guarantees jury trials for civil cases, only applies to common law cases. This was not a mistake. These guys knew what equity was and they knew it was different from common law. So to this day, equity cases are not required to have a jury. The second huge difference is going to be the damages, the remedies. And I'm going to drop a concept on you that's a little complicated, but work with me.
Why men snore after 40 and how to fix it. Most people think snoring is just loud breathing. It's not. It's your...
Drop a concept on you that's a little complicated, but work with me. Common law judgments are also known as declarative judgments because the judge is always declaring something, even when it doesn't sound like the judge is necessarily doing that. Examples of a declaration might be, this contract is invalid, full stop. Or, you owe that person $10. Those are declarations. I don't know why, but that's what they're called. By contrast, our equitable remedies are a little bit different, a little more flexible. Again, these are things like making someone do something, making someone stop doing something. A judge in equity could find a mistake in a contract, and instead of saying this contract is completely invalid, finding some way to make it work. So whenever you come to a court and request an equitable remedy, like an injunction, specific performance, mistake, anything like that, you are filing a case in equity whether you know it or not. Another difference between the two is defenses. Both common law and equity will bar you from bringing a case like way after whatever the thing is happens. In common law, we call it the statute of limitations. It's a common phrase, you know what it means. In equity, for some reason, we call it laches, L-A-C-H-E-S. It's from a French word that means you waited too long. And one of these things that it is useful to know is if you're filing in equity, you would want to claim a defense of laches instead of a claim of statute of limitations. And most people probably wouldn't know that. But again, that's one of those things that lawyers are like, oh, this is that weird case where I have to say that laches word instead of statute of limitations, right? But they don't really understand all of the rest of this. All of this is like, it went out of their brain as soon as they took the exam. And then the final big difference is the flexibility of the judge, which is really in the philosophy. Common law is designed to be stringent. It's designed to be law. It's designed to be very, very clear. Equity is designed to be more flexible, but it's also harder to get into because finding a solution that's fair would be really hard if you were stuck in a really inflexible system. But if you let everybody get into the system that's really flexible, then we wouldn't really need laws at all because everything would be out the window. Okay, so where is equity today? Well, equity is in a lot of countries where England was involved in creating their legal system. So South Africa, Australia, Canada, India also have equity systems of some sort or another. The bankruptcy court is always a court in equity because bankruptcy judges need flexibility to make sure things are fair. They're settling a lot of things that kind of inherently aren't fair, so they're given some flexibility to make changes as necessary. And then certain cases, when they're brought into civil court, are just divided into common law or equity, depending on what they are or what the remedy is. So a case for breach of contract for land, probably going to equity. A case that requires some sort of specific performance, probably going to equity. A case that requires an injunction, probably going to equity. Almost any civil case where you don't see a jury, probably equity. But if you're just asking for money or to declare a contract invalid, probably common law. Okay, so that was our quick as I can overview of equity, our secret hidden court that I find fascinating and I think is really, really interesting. I hope I introduced you to something new and that you found it as interesting as I do. Please keep watching the videos and keep sharing these, and I will keep making them if you keep watching them. Thanks for sticking around, and hope to see you soon. Thanks, guys.
If you need to lose that cortisol belly, do these 5 Tai Chi moves every morning for 2 minutes each.
I'm 62 and today I'm done with the gym, starting Tai Chi at home.
This is me after 28 days. My back pain is gone. I forgot what that felt like.
On Monday, July 20th, we're starting the Tai Chi program for beginners.
All right. Let's go ahead and start this other video that's in the queue. And I've already made comment on the presentation. It's already watched. And so I'm going to go ahead into this one and see what they're talking about on this broadcast.
There's a secret to reading and understanding law and statutes like a lawyer, and I'm going to show you how it works and how to use it. I'm Brian. I make videos about law and civics, so please comment, share, like, repost, and help me get this video out there so people will see it, because this is your law too, and you deserve to understand it. Now, a couple of weeks ago, I taught some of you how to brief a case using the IRAC method, or as I like to call it, the FIRAC method. Don't tell a lawyer that, their heads will explode. Well, today, we're going to take it up a notch. You ready? I'm going to show you how lawyers, and especially law students, use IRAC to learn and understand to read and interpret statute. So we're going to do the sort of exercise that a student might do, even if they wouldn't do it in exactly this form, to understand what a particular law means and how it operates in real life. And since this is me, we're going to start with a weird story with poorly drawn stick figures. By the way, thank you, Pau, for the new markers, because they are awesome. This is the story of Gina and Charlie. So Gina and Charlie are driving down the street in Rockford, Illinois one day because Charlie is finally taking Gina out for a nice dinner for their anniversary. Suddenly, Charlie realizes he's in trouble because he doesn't have any money to take Gina out to dinner. But he remembers that Victor lives nearby. Now Victor owes Charlie $1,000 for a really nice watch that he bought off of Charlie. And Charlie thinks, oh, you know what? I'll go over to Victor's, I'll get the $1,000 from him, and then I'll be able to take Gina out to a nice dinner. So Charlie says to Gina, hey, I gotta go stop by Victor's house to pick up $1,000 that he owes me so we can go buy dinner. And Gina says, oh, Charlie, you're gonna buy me $1,000 dinner? You treat me so nice. But now Gina has a problem because Gina didn't get Charlie anything for their anniversary. But Gina has a plan. When they get to Victor's house, Gina is gonna snoop around and see what she can find, and if nothing else, she's gonna steal that watch back and give it to Victor as an anniversary present. Problem solved. They finish their drive through Rockford, Illinois, and make their way to Victor's house. For any of you who keep asking me why I do it in Rockford, A, I like Illinois statutes, and B, Natasha Leggero used to tell hilarious stories about Rockford, Illinois, and they're just in my head. So, they pull up to Victor's house with the big sign out front, really tacky, that says Victor's Daycare, because Victor runs a daycare out of his house during the day. I mean, no judgment, we all gotta have a side hustle. And they knock on the door, and Victor comes up, lets them in, no problem. Come on in, guys. They're friends. Well, Gina immediately starts her snooping, and Charlie takes Victor aside and says, hey, I need you to give me that $1,000 you owe me for the watch. Well, Victor is incensed because Charlie had told him he had another 2 weeks to pay it back, so he is pretty mad. And he says, you guys get out of my house right now. I thought you were coming in here to say hi because we were friends. You're just here for money. Get out of my house. Well, this is not going to go great because Charlie still needs the money and Gina hasn't found anything to steal yet. So in unison, they both yell, we are not going anywhere. And they don't. Well, Victor thinks about it for a second. He feels like he overreacted and he's like, you know what? Never mind. You don't have to leave, but I'm not giving you $1,000. Well, right then, Charlie gets an idea. He puts his finger inside of his pocket of his hoodie and sticks it out and says, you know what? I got a gun here and I'm going to shoot you right now if you don't get me $2,000 immediately. Well, Victor is really scared because he thinks he's about to get shot and he panics. And so he runs over. Apparently the daycare business has been good to him. So he goes over and opens up the safe, takes out $2,000, gives it to the two of them. Gina hasn't found anything, but she's ready to go. So they take off, they go, they have their nice dinner, they go home and do what you do on your anniversary night. That is the story of Gina and Charlie and Victor. Okay? All right, now let's talk secret code. For those of you who are new here, the code word is IRAC. IRAC, or as I say often, FIRAC. Don't say it in front of a lawyer, their heads will explode. They've said IRAC a million times. The word FIRAC just makes their head spin around. IRAC stands for Issue, Rule, Application, Conclusion. And that is the order that's always used by attorneys, by judges, by anybody in the legal field to write an opinion, to write anything pretty much related to law. It's just how we process information. So that's what we're going to do right now with the story that we just told. Issue, Rule, Application, Conclusion. And today we're going to look at 3 different crimes. And we're going to use the Illinois statutes because, of course, these crimes took place in Rockford, Illinois. Now, the 3 crimes we're going to look at are trespass, robbery, and burglary. We're going to process all of these using the IRAC system, and then we can compare them and learn what the different crimes are.
Hey, it's time to say goodbye. It's time to say goodbye to the buy one, get one free offer from us here at Vanish. Just as I'm saying goodbye to my home office with this new office, we are going to be discontinuing the
process all of these using the IRAC system, and then we can compare them and learn what the different crimes are. I usually frame an issue in terms of under, does, when. Under Illinois law, does a person commit trespass when they do all of the things we talked about a few minutes ago? But to be honest, since we're going a little fast here, we're going to make our issues a little bit simpler, okay? Did Gina commit trespass? Did Charlie commit trespass? Did Gina commit robbery? Did Charlie commit robbery? Did Gina commit burglary? Did Charlie commit burglary? You've probably heard of these crimes before, and you may even have an image in your head of what they look like, but I need you to get rid of those images because chances are they are not correct. Every state has their own laws about crime. They are different in every state, which is why so many people like to argue with me in the comments about what the definition of burglary is, for example. But they didn't steal anything. Yeah, in Illinois, they don't require you to steal anything to have committed burglary. Every state is going to have different rules, and while New York, for example, has breaking and entering, Illinois does not. So quit arguing with me about whether or not it's breaking and entering. It's not in Illinois. It doesn't exist. Anyway, so what we got to do is look up this particular statute for this particular state and see how this state defines it. Now, I'm going to have an assignment for you later, but you might as well hear this now. If you Google Illinois robbery statute, Illinois trespass statute, Illinois burglary statute, they'll all come right up. So go ahead and Google those and you can follow along. So the next step is we write in the rule, and each of these rules has 4 parts. In the state of Illinois, you commit trespass if you, 1, knowingly, 2, without legal authority, 3, enter or remain, 4, inside of a building. In Illinois, a person commits robbery when he or she, 1, knowingly, 2, takes property, 3, from the person or presence of another, 4, by use of force or by threatening the imminent use of force. And in Illinois, a person commits burglary when he or she, 1, knowingly, 2, without authority, 3, enters or remains, 4, with intent to commit a felony or theft. So the next step in the IRAC process is the application. Issue, rule, application, conclusion. So now we have to apply our facts to these rules and see what the answers are to our issue questions. Here's how we're going to do it. So what we need to do in the application stage is go through each of these 4 requirements and see whether Gina or Charlie meet the requirement. If they meet all 4 of them, then they've committed the crime, and that's the answer to our issue question. Now, my system is always to use checkboxes. I find that checkboxes work really well in the law. So for now, we're going to do that. Now, a couple of these rules have ors in them, meaning that it could be one thing or another. That means that to satisfy number 4 here, 2 different things are possible. Here's how I like to lay it out. So first we're going to look at Gina and we're going to make a checkbox for each of the 4 requirements, but watch what I do here. Now, if Gina has met 1, 2, 3, and 4, then we'll check this box down here. Conclusion, yes, she committed trespass. But number 3 has an or statement in it. Enter or remain. So I put 2 boxes here. We can check either one of those to check number 3. And I'll do the same for Charlie. Now let's walk through our story and ask the questions. Did Gina knowingly, without authority, enter a building? Well, Victor opened the door for them and welcomed them in. So no, she had authority to enter when she came in. She knowingly entered, but she had authority. So she doesn't meet those requirements. But what about remain? What happened when Victor told her to leave? Remember that both Charlie and Gina yelled in unison that they weren't going anywhere. At that moment, Gina remained knowingly in a building without authority. Remained knowingly without authority in a building. That means Gina has committed trespass. By the same logic, Charlie has also committed trespass because when he was told to leave, he also didn't leave. Now, it was only for a moment, but this is a hypothetical. This is how we learn. Charlie was asked to leave, and he knowingly, without authority, remained inside the building. Charlie also committed trespass. Now let's look at the other 2 crimes. To commit robbery, you must have knowingly taken property from another person with force or imminent force. Now, imminent force means I didn't actually pull it out of your hand, but I told you that it was about to be pulled out of your hand. Robbery's second requirement says that you must have taken property from someone. Gina never took property from anyone. She was going to, but she didn't do it. So Gina has not committed robbery. Gina's missing that second one. No robbery. Now remember, initially Charlie was coming in to get $1,000, but he changed it to $2,000. So Charlie knowingly took property from Victor, another person. Did he use force? No. But did he use imminent force? Well, he said he had a gun in his pocket. Even though he didn't, there was no reason for Victor to know that he didn't. So he implied that there was imminent force coming if he didn't turn over that $2,000, and Victor turned it over, showing that Victor believed there was a gun there. Imminent force is there. Number 4 is met. Charlie has committed robbery, but Gina has not. Now let's break down burglary, which we did in the last Iraq video and people went crazy, so we'll work with this. Burglary has 2 or statements in it, which makes it even more complicated. So I'm going to write it out as cleanly as I can. In order to commit burglary in Illinois, you must knowingly and without authority enter or remain with intent to commit either a felony or a theft. Okay, so we have 2 or statements here. I got in so many fights with people about intent in the comments. Here's the deal. This isn't a real story. I made this story up. I'm going to tell you who has intent and who doesn't. So don't argue with me about intent. We'll get to intent someday. It's a whole topic on its own. What's important to understand here is when the intent was formed, because that's what it says in the law. So this is really the part we've been building to, because this is going to get really interesting. At some point in our story, did Gina intend to commit a theft? Yes. Did Charlie intend to commit a theft at some point in our story? Yes. But did they intend to commit those thefts at the same time? No. They intended them at very different times. In the end, Gina didn't end up committing a theft. Charlie did. But what matters here is not actual theft, but intent. Theft is not one of the requirements here. As we showed you in the last Iraq video, you can be charged with burglary without actually stealing anything. What matters is that you intended to steal something. So let's look at our story brick by brick. Now, our first or statement is entering or remaining. And there's sort of 2 points here in our story, because at one point they enter the house, and at another point they remain in the house because they're told to leave and they don't. When they enter the house, does Gina already intend to steal something? She does. Does Charlie already intend to steal something? No. But Gina enters the house with authority. So even though she enters with the intent to steal something, she's invited in. So her entry cannot meet the requirements of burglary. And since Charlie did not intend to commit any sort of a crime when he entered the house, his entry cannot meet the requirements of burglary. Now, if anybody's thinking, what if the watch he sold fell off the back of a truck, and by completing this sale, he's actually committing a crime and it's a felony? I like the way you think. I thought of the same thing, but we don't have that information and evidence. We're not going to bring that up right now, but I see you. The point is that when they entered, neither one of them met the requirements. But what about the moment of remaining? Now, if you recall, Victor sent them out of the house, said, you guys have to leave, and they both said, no, we're not leaving. But then a minute later, Victor changed his mind and said, never mind, you can stay. So in that, let's say, minute, when they were remaining without authority, knowingly, did either of them intend to commit a felony or theft? If so, they will have met all of the requirements and they will be guilty of burglary. Let's look at Gina. Gina intended to commit a theft from the moment she walked in the door until basically the moment she walked out. Right at the end, she decided, and walked out the door. But her intent didn't change until well after their authority had been returned. Gina knowingly, without authority, remained with intent to commit theft. Gina is guilty of burglary. What about Charlie? Charlie came up with 2 ideas right after he was given authority to remain in that house. The first was he was going to pretend to have a gun, and the second was to change the number from 1,000 to 2,000. Those two things were definitely intent to steal, but they came right after authority to remain was returned. Charlie had the intent for theft, but he did not remain without authority. We don't have the elements. Charlie is not guilty of robbery. Now, here's what I want you to get out of this exercise. First of all, once again, every state has its own criminal statutes, so they're always going to be different. Find out the ones for yours, take a look at them, put them into checkboxes, see what they look like. Second, this is sort of how we as law students learn the difference between these crimes. We get hypothetical stories like this, and we apply them to the different patterns and see which ones apply and learn the differences. So now I have a little something, we'll call it fun for you. I'm not sure if you'll find this fun, but if you do, we're in this together. Okay, I have put some little Easter eggs in this story. You go to Google and Google the Illinois statute for trespass, robbery, and burglary, you're going to find a much longer statute. I only gave you kind of the first basic line of each of these. There's different degrees of these crimes, there's different levels of felony, all kinds of extra stuff. Go through those, take a look, do this process, and see whether anything else in this story sounds like it might be a different crime, higher, lower, anything special. And pop that into the comments. Tell me what you find. And go ahead and analyze the $1,000, the $2,000. Go into all of that. Take a look at it and compare it against the other layers. Because that's what a law student does. That's what a lawyer does. And now you're starting to think like a lawyer. All right. Thanks, guys, for watching. This was really fun to make. I hope you enjoyed it. I hope this was helpful. And if you have any questions, please share them. Again, I want to thank Pal for sending me new markers because mine are running really low and these are way better. And I want to thank the person who sent me the new filter for my car because that's super useful.
Wow. Okay. Bless his heart. All right, we've been running this broadcast for, thanks for the likes. We're running for about an hour, and I think we've gotten some very useful tips and information out of the broadcast, and that is its purpose. Thanks for